Welcome back to the channel. In today's video, we are talking all things patent application, and I am joined by Vicky from Pure Ideas, who is a chartered UK and European patent attorney, to look at all things to do with the patent application process. Now, it is quite a complex process, but it is critical if you're a business owner developing new ideas, or you're an entrepreneur and you've got a new concept, that you understand the process and what's going to be involved. You might think I can just throw all that onto my patent attorney and they will deal with it for me. And to a degree that's true, but they're going to be spending quite a bit of your money, and it would be best if you understand the process and what they're doing for you. Also, there are some tips and tricks in this video that could actually save you thousands of pounds on the process, and so make sure you keep watching right until the end to get the benefit of all of that.
Hi, so I'm Vicky. I work for Pure Ideas, which is an IP advisory firm. I'm a patent attorney. I've been a patent attorney for about 30 years now. The first thing to remember about filing a patent application is that you must not have disclosed the information in there prior to filing your patent application. If you have done, this can come back and haunt you later, and your patent can be revoked or deemed invalid down the line. So if you have to have conversations before you actually file that patent application, be sure to get a confidentiality agreement in place. Even then, if there's a breach of that confidentiality agreement, that can be troublesome. So really, as a last resort, do try and get that patent in before you speak to anyone about it.
Yeah, that's a really important point, Vicky, isn't it? Because actually you can be tempted or need to talk to potentially retail buyers, get some feedback, or you might get some market research from your customers. A lot of our clients also want to get costs from manufacturers. But I think what you're saying is make sure you get your patent filed before any of that happens.
Definitely, if it's at all possible. So one thing we sometimes encounter with clients is that they file their own patent application and they then come to us later to deal with the more complicated side of the process. Now, whilst it's fairly easy to get a filing date for a patent application, this can come back and haunt you if you haven't got all of the right information in your patent specification at the start. The thing about patents is, as you go through the process, you cannot change or add to the disclosure that you've described in your patent specification, which can mean that subsequently you could end up not getting a patent granted.
Yeah, and we've had this actually with a couple of our clients as well, where they've wanted to change it because they've built another prototype or something else has come to light, or they've had some feedback from a retailer. And then unfortunately, what's ended up happening is if you want to protect that new mechanism for part of it, whatever, you're actually going to have to file a whole new application.
Absolutely, yes. And it may be too late if you've already published your initial one at that stage.
And I believe you can also end up with a difficult situation where your first patent is almost counting against your second one as well.
That's absolutely right.
So the message is get everything you possibly can into your patent application, because you're not going to be able to change it later on in the process.
Yeah, definitely. So another thing to consider when you file your patent application is the search and examination fees. Now, there is an opportunity to delay payment of those when you first file your patent application, and that can be tempting because the whole process can get quite expensive and you want to generate some investment first. However, there is a downside to that. If you leave it until the last minute to request your search and examination, you can end up in a situation where you do not get the results of that search report until after your patent application is published. Now, it may be that the search and examination report gives you an indication that you might not get something granted, or that you need to rework or come up with some new material in your patent application. Once your patent application is published, if you don't subsequently get your patent granted, then you've disclosed your good idea to your competitors, who can then go away and copy it free if there's no subsequently granted patent. So get your search and examination fees in early, get those reports back, and use that to help you make a decision on whether you want to proceed with filing overseas, which is something you can do after 12 months, and also the option to actually withdraw the publication before that happens, so that you're not sharing that information.
So I guess that could be really critical then. If you're not actually going to take that patent application forward at that time, you don't want it published, because as you say, your competitors could then see it. But there is an option then to withdraw the application before anyone ever sees it.
That's right, yes. So you can withdraw it, take it away, rethink, and apply again later, provided you haven't to discuss that.
Oh, that's great info. Now, I've worked with clients with innovative ideas who've been patenting or final registered designs for many years, and some of them have, on occasion, tried to do it all themselves and do the drafting and the filing. I have to say, none of them successfully. And probably from this video, you're picking up there's quite a lot of complexity that needs to be thought about. And my advice would be absolutely use a chartered patent attorney to make sure that your application's got all the right details in it and that you don't fall foul of any of the particular rules or guidelines around getting your intellectual property protected. The patent application itself can run to many pages. I'm sure you'll tell us in a minute what your longest patent ever has been. My personal patent on the pushchair product, I think, was about 56 pages, about 24 different claims. And you really want to make sure that is worded very well and to give you the broadest scope of protection possible. So make sure you use a chartered patent attorney, someone like Vicky. The link is in the description below to Pure Ideas, the company that Vicky works for. And one thing I've noticed over the years is that it is possible to draft a patent specification too narrow, and you then make it very easy for competitors or other people to work around that and launch a product that does the same thing or has the same benefit without infringing on that patent. So you do want to make sure it's broad, and I think one of the main values a chartered patent attorney brings is giving you the broadest scope of protection possible from your patent specification. I don't know if you agree with that.
I do, definitely, yeah. That's certainly one of the skills we try to hone when we're training. So we're caught in this balance between we need to craft claims that will protect your idea, but which don't embrace similar things that have already gone before, but as you say, which aren't so narrow that they only cover one version of what you could do and allow competitors just to be inspired by your narrow patent.
So it's almost like a tightrope, isn't it, between being too narrow so that other people can work around it and too broad so that the examiner basically says you can't have that, that's not specific and inventive enough.
Yeah, it's a fine line.
It's that fine line. So make sure you get your patent specification drafted correctly. That is going to involve inevitably the support of a chartered patent attorney, and I'd say make sure you tell them everything you can. If you've had 3 or 4 different ideas to get to your final one, well, give them all of that information as well so they can include any of their best bits of that might give you a broader scope of protection. If you're finding the video useful, make sure you hit like and subscribe before we go on to the next tip.
So during the search and examination procedure, when we're prosecuting your patent, it's quite often involves legal arguments why there is an advantage to your particular new idea over what's gone before. So it can be very helpful when initially talking to your patent attorney, and sometimes to include in the specification some kind of summary of problems that you've noticed with the existing prior knowledge that your invention seeks to solve. So if your invention provides an improved product because it's solved a particular technical problem, it's really useful input to a patent attorney to know what that is, and that can be very persuasive in terms of legal arguments to the patent examiner. The most critical part of your patent is the patent claims. So they define the legal language which defines the monopoly essentially that you're being granted. So they need to be both, as we've discussed, not embrace what's gone before, so not embrace the prior art, but also to embrace the underlying concept that you've come up with and not just one particular embodiment of how you do that. So this is where your patent attorney really earns their money in this situation. So you will find that during the course of the examination procedure, it's not unusual for the claims to be changed as you go along. And that isn't because your patent attorney got it wrong in the first place, it's because they're carefully trying to find that balance, and you may need to just tweak the language a little bit to address those 2 issues of avoiding the prior art and making sure the broadest concept is covered.
And so normally you've got your patent attorney responding to the examiner from the patent office, is that right? Intellectual property office, sorry, no longer the patent office. So you end up in this kind of back and forth, is that right? As you try and work out exactly what it is in the claims you can get through to grant.
That's right, yes. We argue with patent examiners for a living, basically, which can be a lot of fun.
And when you say change, so you can't obviously add in anything new at this point, I'm guessing, because we've talked about that in a previous video, I think. But you can then modify your claims from the feedback that the examiner's giving you to try and deal with any of their objections or concerns.
That's absolutely right, and that's why it is crucial to make sure you have all the right information in your patent specification at the start, because you can't add new language can do with the claims is to pull out features or general language that you've already incorporated in the main specification and use that to enhance the claims, to clarify them, or to add new features to them to overcome objections that are raised. Yeah, that's really why I can't state how important it is enough to make sure it's right at the start.
That makes a lot of sense. A well-structured and carefully drafted patent application can protect your new idea and make sure that you have monopoly rights on that so that you can benefit financially from it. However, as you can see from this video, the application process is not straightforward, and we would highly recommend you use a chartered patent attorney who really knows what they're doing to get it right. Vicky, for example, check out the links in the description below. Having heard all of this, you might be wondering, are patents really worth all the time, effort, and inevitably money that you're going to have to put in to getting the application granted? We think the answer is yes. Find out why by joining us in this next video.